that they may not get a redress in due course. That is not demonstrated before you. It is said the application is urgent, we say it is not. But one thing that her ladyship you can read the founding affidavit from A to Z, you will not find where the applicant says, I will not be able to get a substantial redress in due course. That on its own is fatal in an application for agency, or based on agency. I just want to deal with this question of agency in detail, but I have these questions in my mind. Is it in the interest of justice that the NPA should work on the convenience and timetable that is set by an attorney? In a simple matter where it's not a trial, it's just a question of handing over your client so that he is processed and then is taken to court. Would it be in the interest of justice? And if so, what is that going to do to the public confidence in the criminal justice system going forward? Where we have applicants who will simply say, wait for me, wait until I'm done. In fact, in this case, if the applicant was in hospital, it would be a different story. In this case, it's not even the convenience of the applicant, it is the convenience of the attorney. The ladyship is going to ask me, doesn't she have a right to an attorney or to be legally represented? We accept that there is generally a right to legal representation, but Section 35 is specific of the Constitution. At this stage, the applicant is neither arrested, is not detained, is not accused. At this stage, she is just a suspect. Section 35 is specific as to who has those rights. It is a person who is arrested. I propose not to read, but subsection 3 is specific to a person who is accused. Once the applicant appears, once the applicant is handed over, she is told of the charges against her. It is at that stage that the obligations, for instance, to inform her of her rights, even the right to legal representation, arises. But at that stage, then she becomes entitled to legal representation. At this stage, to say...
Not only that, as the case will not over and over say that you're right, you have a right to legal representation, but not to a specific legal representation.
Yes, well, from the time we conducted her, the purpose of conducting her was twofold. And that relationship was on the 8th of March. The purpose was twofold: to inform her that we intend to take her to court. And Mr. Perlman says, I asked her who her legal representation is, because these are legal matters. And Mr. Perlman waited until she got an opportunity to appoint the legal representative. So there is no denying of the applicant's legal right to legal representation. In any event, strictly speaking, at this moment, she is only a suspect. I don't understand the argument by my learned friend that she is presumed innocent, but she is taken. I couldn't follow that philosophy. But the leadership, is this matter urgent? Because this leadership must also consider that. This is what we say: this matter is not urgent. On the 8th of April, as I said, the applicant was conducted. And
8th of
March. It is this 9th of April that what is thinking about. And then on the 9th of March, your leadership, it is then that she was specifically informed that we intend to take you to court. And she was told that a decision to that effect has been taken. As for the details of the legal representation, and she promised that I will revert on that one. Again, on the 11th of March, 2 communications were done by WhatsApp and by direct call. Again, it was indicated that we intended to secure her attendance in court, and that we gave a date, we said at least by the 13th of March, which is now gone. She said she would only be back on the 16th of March. We accepted that. And then the applicant's attorney gets involved on the 17th of March. The first thing that the attorney does is that he requests copies of the docket. Up to so far, it is unheard of that copies of the docket can be disclosed or can be demanded for any other purpose, like, as they say in paragraph 12.4, I think, of the founding affidavit, that they want to defend themselves against the media. That is not the purpose of disclosing the evidential docket. And of course, he indicated that he will only be available on the 3rd of April. But there has been a discussion First, they discussed that can he be available on the 20th? This is after he had said on the 3rd of April. Can you be available on the 20th of March? Can you be available on the 22nd of March? All these are the engagements that are between them. And fundamentally, there is nothing that was ever said to the effect that we want to arrest your client. All that is said is bring your client with yourself. And the deponent to the answering affidavit says, I even told them that we want to do this matter as seamless as possible. All right. And then, Your Lordship, on the 19th of March, this is now I'm talking about the topic of undertaking. On the 19th of March, there's a discussion between Mr. Perman and the applicant's legal representative. In that discussion, you find it in our answering affidavit in paragraphs 40 to 51. In that discussion, Your Lordship, the applicant's legal representatives asked for an undertaking. He says, please give me an undertaking that my client is not going to be arrested. That undertaking was not given on the 19th of March. And then, Your Lordship, still on the 17th of March, the applicant's legal representative is informed by the public prosecutor now that we want your client to come, present herself at the police station, Littleton police station. We process your client. She goes to court. We are not going to oppose bail. It was made upfront. I'm making an emphasis on this, Your Lordship, so that His Lordship is aware that there is no threat of a detention. This is a matter of, it's a procedural matter to process the person so that the matter is enrolled and the trial gets underway. But importantly, Your Lordship, on the 19th still, the applicant's attorney writes a letter. My learned friend has read that letter, but we deal with it at paragraph 66.11, paragraph 66, but particularly at paragraph 66.11 of our answering affidavit. We point out that in that letter, the applicant's legal representative requested an undertaking. This is now on the 19th of March. The undertaking was not given. Then what they do, on the 22nd, they bring an application. That is on Friday last week. They bring an application on the basis that an undertaking not to arrest has not been given. They sent that application on the 9th of April. Barely few hours, let's say 5 hours, 6 hours, the applicant's legal representative asks for an undertaking that there is not going to be arrest. The application has now been served. The application was served around 6 in the morning. Around 11 during the day, he asked for an undertaking. And if you do not give the undertaking, I am going to court on an urgent basis at 3 o'clock this afternoon. The undertaking is still not given. Then on Saturday, that is the day before yesterday, they bring an application. On what basis do they bring the application? On the basis that the undertaking has not been given. Now, the undertaking was never given at any stage prior to the 22nd, or even prior to the 23rd. It was never given. And when the undertaking was not given, they set the matter down on the 9th of April. But on the same ground of not giving the undertaking, then they say they are anticipating the date, and they are bringing forward to today. Not only do they not comply with the practice directive, they do not give us sufficient time to prepare the affidavit and to prepare a proper argument to present before Your Lordship. Now, they say, the applicant says, perhaps I need to refer this time to it is page 16, Your Lordship, 00-16. Thank you, my lady. The focal point will be paragraph 36, but in the preceding paragraphs, they refer to a communication between Mr. Manyati and the applicant's attorney. And the attorney writes a message to Mr. Advocate Manyati. He says, we haven't heard from you in read the application served and received by yourself this morning. So it's on Friday. He says we have not heard from you. Bearing in mind that in the notice of motion, you are told to react by the 26th. It's still way before the 26th. We have been watching the reports in the media which seem to indicate an imminent arrest, and even on one which stated that my client had lied about her whereabouts. The media has also congregated around my client's house, no doubt in anticipation of such arrest. I'm going to deal with the so-called leaks later on. And then he says, we have taken the decision to accelerate and seek an urgent interim interdict against my, to interdict, I think he wanted to say arrest, against my client's arrest at 1500 hours today. Mark that today. Today in Pretoria High Court. And let me not read further. Then in paragraph 35, Mr. Manyati responds to that message. We have no control over the media. The fact that the media has congregated at their place, at least not at our instance, we have no control of that. And then he says there is no imminent arrest and therefore no need for an urgent interim relief today. Remember, he said, I'm going to court today. And he says, no, there's no need to go to court today. There's no imminent arrest. We are not arresting. And then in paragraph 36, can you get our response to paragraph 36 in the answer affidavit? In paragraph 36, they say they accepted what Mr. Manyati said, and they accepted that this removed the need for urgent interim relief until we became aware of comments which Mr. Manyati had given to the press, which was as follows. Then says, not my WhatsApp, I don't know what that means. Evidence by SGM6, that's the annexure to the founding affidavit, being a media report published at 600 hours in the morning. This now is on Saturday. Yes, we actually said very clearly, not today. Nothing less, nothing more. This is exactly what is contained in paragraph 5. In paragraph 5, read in context with the discussion that they had, he said there is no imminent arrest and no need for an interim interdict today. But then they say this has escalated the urgency of this matter. We say, my lord, my lady, that whether one interprets this to mean that the arrest was not going to happen on Friday only is of no moment. Of no moment because we have never given an undertaking that there is not going to be an arrest. So if the matter was urgent because we did not give an undertaking, it would not, it would, and they needed an urgent relief as in today, they would not have set down the matter down. They would not have set the matter down for the 9th of April. They would have brought it today. But the point we're making is this is an abuse of court process. You can't allow a litigant to initiate a process, and when that process has been initiated, he abandons. He takes the matter out of the court road, having jumped the queue, wants to jump the queue again. That should not be countenanced. I did not emphasize the point that the practice directive has not been complied with. We are here on Monday. At least there has to be an explanation in the affidavit why one cannot wait for Tuesday, why the papers could not be made ready on a Thursday, 12 o'clock. The other aspect I would like to deal with is then if her ladyship finds that the matter is urgent, and then the applicant has got to demonstrate the requirements for an interim interdict. I want to start with the irreparable harm because that is what my learned friend has dealt with. And he dealt with the irreparable harm by reference to the case in Johannesburg, in the matter between the president and the other president. What was the court dealing with in that matter? The court, Sutherland DJP, was dealing with an unlawful prosecution by a private prosecutor. Unlawful prosecution by a private prosecutor. First, although in the affidavit they say the arrest hearing is unlawful, it is not substantiated why it is unlawful. And at this stage, it cannot be assessed that the arrest is going to be unlawful or is unlawful. Once it has happened, then one can look back and check if it is unlawful. But the facts are distinguishable in the sense that that was an unlawful prosecution by a private prosecutor. Not the NPA has been statutorily assigned the function of managing the prosecution, not necessarily the private prosecutors, but worst of all, when the summons issued by the private prosecutor are unlawful. What then Judge Sutherland says is that I'm talking of the import of what he's saying. He says the irreparable harm would result by virtue of submitting to that unlawful prosecution. This is not an unlawful prosecution, as we said. And this is not an unlawful arrest as well. The election will make the point that there is no one who would claim a right not to be arrested, because this is what the issue is here. And the election, I do not understand this preference that the applicant seeks to be treated specially. What the prosecution is doing is acting within the law, but the applicant has her own preferences how this process should be undertaken. If we were to allow that, we are going to have a huge problem, in the sense that all 57 million people in South Africa, if let's say half of them, not all of them can be charged, because the judges will majority of people will always say, no, don't call me to court this way, call me to court that way. Then we would never exercise our discretion. We might as well forget about the discretion that the law gives to us. We might as well just go and beg to the accused, to the suspect, as to what must we do then in the circumstances. But this case demonstrates the problem that we will encounter. Someone will say, I want to be arrested, I want to appear in court, I want to come to hand myself in court in November, because I have these other things that I need to do before that. That is undesirable. That is not in the interest of justice.
The whole argument is it's only 2 weeks, so it's reasonable.
It is not. It is no. It is not reasonable insofar as they want an undertaking from us. What we have done, we have been courteous to them. We did not just go and arrest. We could have done that. We could have just gone and arrested, but we chose not to do that. We said, let's do it in a seamless way. And this seamless way, your leadership, I submit, is also less invasive, because we are not taking it. She is brought by the acting. She's taken to the court by the acting. All we want is so that the court can fix bail. That's all. Our colleagues, they say, let us issue summons. If you do that, then it will never be an issue about. There will never be a talk about bail. In other words, the court will not be given an opportunity to fix bail. But whether that is the case or not, her leadership would urge her to bear in mind that an arrest is one of the legal ways that are statutorily available to the officers. Now, what the applicants are doing, they want to frustrate us in the performance of our statutory function. Now, we refer you in our case to the case of Porter, where it is said, if you're interdicting the functionary from performing its statutory function, then the bar is high. There is no exceptional circumstances that have been demonstrated here. The best they do, they say, this is a Speaker of Parliament. There is an ANC constitution that says if he is charged, she is charged, she will be required to step aside. We can only read those as the exceptional circumstances that they are putting forward. Those are certainly not exceptional circumstances. We submit your leadership that the law knows no positions. The fact that I'm an advocate, the law, when it has to grind, it must grind. It will not wait for me until it will not grind differently.
Well, the rest should be the last resort.
The leadership
should rather use the summons procedure on these facts.
Well, we don't even know what those facts are. But what we know is Section 40 of the Criminal Procedure Act tells us the circumstances under which an arrest can be done. All we need to do is to comply with Section 40. If we comply with Section 40, if we exercise our discretion properly, and which is something that can be assessed after it has been done, there can be no question at all. Which your question also brings me to what is called the judicial peak. Maybe I should just look into that as well. Here they want this court to look at the docket and decide whether on the evidence that is in the docket, there is a ground to arrest. That is not a function of the court to do so. That function is assigned in terms of Section 40 to the police. Once they have, for instance, a reasonable suspicion that an offense has been committed, then they can arrest. It doesn't go further than that. Second, Your Lordship, we view this submission of a judicial plea as a review by backdoor. They want Her Ladyship to review the decision, but they do not come up forthright to ask for a review. But in effect, this is a review. It is not appropriate, Your Lordship. But also, we submit that the judicial plea cannot be done in this matter, because when the applicant seeks a relief, she must present evidence. In this case, the applicant was supposed to say, I have the docket, here it is, and submit it to the court and say, look at it, court, does it warrant it? But they have not given you that opportunity. You don't, in the papers that are before you, you don't have anything to pick into. Your Lordship, you are in court on an agent basis today, for instance. The applicant is represented by a contingent of 4 legal representatives. What is the problem? Why couldn't they just take the applicant today, for instance, now that they are in court? I understand Mr. May is not here, but why can't the attorney who is present in court take the applicant to the police station today? There's no reason at all. Your Lordship, I also have got a problem with the prospects of success in the main application that we are seeking. They are
So I
seeking.
want to ask you, let's for a moment accept, and I'll just plain legal status, that I find that it is urgent.
Yes.
If I should rule on the arrest and the judicial plea, that court will be bound by what I have said.
Definitely.
And that matter would more or less basically
Fall away, yes. Definitely, it will fall away. But let's look at the prospects of success in that matter. The prayer they seek is a final interdict that their client, the applicant, should not be arrested at all. That's the first prayer. Why would the applicant not be arrested at all when the law says we are all equal before the law? Section 9 applies, the law applies to the applicant as well, in the same way as it applies to me. Why should she not be arrested at all? Because that's what the relief they are seeking. That order is undesirable. And it is without any condition. Do not arrest me. So if the applicant is not arrested, she may in fact decide not to go to court, because she has got an order that she cannot be arrested. Even if you were to serve those summons, you can't arrest me. I've got an order. So that relief is undesirable. It is inappropriate. In paragraph 3 of the notice of motion in that application of April, they seek access to the docket, as Her Ladyship knows. But at this stage, it is not yet a trial stage. We have referred in the answer, we've quoted a case in the answering affidavit, the case of Shabalala. That right to access the docket.
I'm not following the argument. The argument seems to be, because you've now said that the investigation is closed, that seems to be what triggers when you're entitled to the docket. When the investigation is closed, that seems to be the trigger.
In other words, they are saying a suspect is entitled to the docket at a stage when she has not been charged, when she has not been informed of the charge against her, when she is not at a stage where she is preparing for a trial. That does not make sense to me at all.
Well, is that practice at the moment?
No. Hence I say it is unheard of. I was hearing it for the first time that one can demand. What we know from the law is that an access to the docket is given so that the accused person prepares for the trial. Yes. In any event, what we submit in this regard, it can never be urgent at this stage that one have access to the docket. Your Lordship, the fact that the submission is that it is only a matter of 2 weeks, it seems that it goes back to what I'm saying, that it will be treating people according to their preferences and according to their status in the society, which is something that cannot be accepted. If we make that undertaking, then tomorrow every other suspected person is going to be here in court and say, please tell NPA that I want to go to court in May. That cannot be countenanced. It will collapse the justice system. May I just take instruction? Is the charge? Okay. The Lordship, we have set out in the affidavit the facts that demonstrate that the charges that are preferred against, that to be preferred against the suspect, the applicant, fit in within, say, Schedule 5 offence, which brings in provisions.
Schedule 5?
Yes. It will be Section 60, subsection 11, subsection B, which says, notwithstanding any provisions of this Act, where an accused person, a person who has been processed, the fingerprints taken and so on, is charged with an offence referred to in Schedule 5, but not in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court judge it is in the interest of justice permit his or her release. In other words, we are dealing with a situation where this person must go to court. In fact, this argument that she must come by summons is neither here nor there, because at the end of the day, she must be processed, which is what we want to do, and then she must appear in court and be dealt with in terms of this section. So it's really a preference that should not be permitted to the applicant. The Lordship, my junior wants me to deal with this thing now. I wanted to deal with it at a later stage. We are told that we are leaking information. What was that? We are leaking information to the media, and we are not told who of us is leaking information to the media. I want to demonstrate to your Ladyship now what, for instance, they say in paragraph 35 of their founding affidavit, when they say Mr. Mzinyati has spoken with the media and told them that we are not going to arrest today. Mr. Mzinyati, in paragraph 1, I'll give your Ladyship the page number. It's page 61 to 62 at 5, section 5, 005-61, 005-61. In paragraph 103.3, he says, I deny vehemently that I have ever spoken to any journalist or media house in relation to this matter. Therefore, the alleged comment by me is denied. Much as you have not been given an audio discussion between him, allegedly between him and the journalist, but what they do, they simply ascribe that to him. They talk about us leaking the Section 204 statement, but they do not tell us who leaked that Section 204 statement. What I do not understand all these allegations. Your Lordship, we take a dim view to these allegations. We have no responsibility on what the media reports, how the media. We've got a media liaison person. We issue press statements. We don't deal with unidentified sources. So if they say we have leaked information, they must identify that person. Tell us when, who, and how was the leak done. My learned friend has read to you the letter where it was said, if I'm paraphrasing, if you do not come, if you do not bring your client, then we will then be forced to resort to Section 40, which is a last resort. That also tells you, Your Lordship, that we don't have an intention of simply arresting this person for nefarious reasons, as they say. We've given her the courtesy, we have applied the less evasive name, but what she cannot do is to prescribe how we should handle the matter. Your Lordship will ask in the end, by the way, insofar as the balance of convenience, nothing is said in the founding affidavit at all. So that too has not been established. The applicant basically she says her right to dignity, her right to freedom of movement, those are the rights that I will deal with the right to dignity and good reputation as they put it now. The freedom of person is not unduly interfered with. by the process of her presenting herself in court and then being taken to.
So I think you have to address me on that.
Yeah.
Fine, that is what you want, then you don't have to.
As a court president, the dignity, because of the media that has reported widely on this, any dignity that she has is not going to be repaired by her not being called upon to court. The media has already, in fact, there will always be those suspicions, even if we were not to prosecute her. So if there was any reputation, there was a reputation, I accept. She has got a reputation, but that reputation has been damaged already by the media. There's nothing to protect any further, at least not by way of this indictment. We submit your lordship that you should strike off this application because of lack of agency, non-compliance with the practice directive, and in particular because they are not making a case that they will not suffer any irreparable harm. And if her lordship is with us, we submit that the cost should include the cost of 2 counsel.
Thank you very much.
And the purpose.